Well, hello everybody. My name is Sofia Koze, and I would like to tell you today about subjects of international public law. I would like to answer the following questions. First, what does it mean to be a subject of international law? And second, who do we count as subjects of international law? Let's start with the first one. The international public law means the set of rules, norms, and standards regulating mutual relations between states and international organizations and other participants of international relations having the ability to act in international relations. I will start from the last part of this definition, which is, quote, having the ability to act in international relations. To have subjectivity, like a kind of personality that allows someone to act at the international legal arena, means first, to have an ability to have rights and obligations. Second, to be able to directly incur such rights and obligations, the ability to act in international relations, such as maintaining diplomatic and consular relations, participating in international organizations, concluding international contracts, pursuing claims by referring to peaceful methods of settling international disputes, exercising diplomatic protection, bearing international responsibility, etc. Sometimes it is said, especially towards states, but also in case of some organizations like the European Union, that to have an international subjectivity means to have free use as rights. First, use tractatum, also known as use contrahendi, so the ability to conclude international agreements, use legationis, the ability to maintain diplomatic relations, and use standi, the ability to make international claims and bear international responsibility. We can divide mentioned subjectivity into primary one and secondary one. The primary one is closely related with sovereignty. In fact, it is a consequence of state sovereignty independence. Also, the subjectivity appears, this kind of subjectivity appears, one can say, automatically when a new state arises. But let's remember, though, that to be recognized as state, some conditions must follow. The secondary one is a subjectivity given to some entities by interested states. States create it in the constitutional agreement, which is the basis of a given organization, granting it legal capacity. The secondary subjectivity won't be as full as the primary one. It will meet some restrictions, lesser or bigger, depending on the intention of the creating states. Also, for primary subjectivity, it is equal for all. States are equals at the international arena in the meaning of having equal rights, the right to conclude international agreements, etc. In other areas, countries of course differ, like in economic potential, territory size, population. While the secondary subjectivity varies considerably depending on the competences and purposes for which the organization was created. Talking about states and organizations, it gives us a hint to the answer for the next question. The second question was, who do we count as subjects of international law? Answering this question is really, really important because it leads to determining the entities that are bound by international law and separating them from those who are not, whose sphere of existence is regulated by domestic internal law of states only. In domestic law, like in the Polish Civil Code, we may usually find a clear definition of who has legal subjectivity in the meaning of who may be the subject of the rights and obligations and who may undertake legal actions. But how do we know who is the subject of public international law? Well, there is no general legal rule, competence in the area, in the international law that would straightforward answer that question. The term international community is in a narrower sense refers to all the sovereign states that maintain relations with each other. Those relations are regulated by international law, but in a broader sense, the international community also includes non-sovereign entities It asks all participants of international relations that have the ability to act at the international level, whose rights and obligations are defined by international public law. And now we will discuss the subjectivity or the possibility of the subjectivity for the following. Let's call them actors, as they may or may not, we'll see, act in the international arena. States, international organizations, which we can distinguish between governmental organization and non-governmental organization, multinational corporations and individuals, legal persons and natural persons. States. States can act in the international arena for sure. They are fully fledged actors. But for the state to be recognized and be able to participate in the international relations regulated under international public law, it must meet some requirements. The states consist of components. The components are population, territory, and the highest authority. Some recognize also both the ability to maintain relations with other states under the Convention from Montevideo on the Rights and Duties of States of 1933. A new state arises when a certain community obtains with a high degree of probability, stability, an organized government, a specific inhabited territory, and a degree of independence from any other state that enables it to conduct its own foreign relations. For the state to be a subject of the international law, it has to have an effective, stable government. An interesting example of a significant role of effective government are governments in exile during the Second World War. A government in exile is a political group which claims to be a state's legitimate government, but is unable to exercise legal power on its territory. It instead resides in another country, foreign country. That's an example from my own backyard, as for Poland during the Second World War, the effective government in exile worked from across the borders against the occupants. It was first stationed in France and then in the United Kingdom. Even though for the war period Poland has lost its territory, it maintained effective government that worked against the occupants. The concept of state subjectivity is inseparable from the concept of sovereignty. A term sovereignty is sometimes put against, compared with the term independence. In many cases, they actually mean the same thing. To be sovereign, as a country means a lot. To be free from any external factors, to have supreme power or authority within territory, to be able to set legal rules in the state, to regulate all spheres of life of our citizens. But are we as states utterly fully sovereign in 21st century? We need to change our approach to understanding sovereignty of state in the era of globalization and worldwide international cooperation. States can shut down, exclude, silence their competences to regulate some area of life in order for these competences to be executed by international governmental organization. But it's still, the country still maintains its independence. When a new country is created, a new state can appear in the result as a result of war, though in many cases condemned by United Nations and the current peace policy, or as a result of the peaceful process. Currently, we do not have territories which were called res nullius, so territories that belong to nobody, which was one of previous methods of creating a country, discovering this res nullius and setting up a country there. Therefore, the state can be formed by separation from existing entities, like African countries in process of decolonization, the breakup of such entities, so they cease to exist, like in case of Soviet Union or Czechoslovakia, which is now divided to Czech and Slovakia, or their combination, in case of a unification of countries like Germany or Italy. As for sudden disappearance of a member of international community, giving up the jus ad bellum, that is, the right to war, that eliminates one of previously permissible ways of said termination of existence. The international law rarely interferes in the process of creation of a new country, treats a country as a phenomenon that just simply exists. Exceptions in forms of supporting decolonization or disacknowledging, refusing to accept some acts, like the Declaration of Independence of Rhodesia, announced by the racist government of the white minority in 1965. Decolonization. The process of liberating the colonies was initiated by the formation and separation of the United States from England in 1776, and the liberation of South America from Spain during the 19th century. The decolonization process intensified after World War II, achieving its peak in 1960s and 1970s, when the United Nations was enlarged by almost 100 newly formed states. Another very important issue connected with the situation in which a part of the country's territory breaks off, or when the country ceases to exist and splits into other subjects, is a problem of international succession. There is a problem of accepting rights and obligations after the previous subject. Succession is the result of change in territorial authority over part or all of a specific state territory. And the subject of succession may be international agreements, non-treaty obligations and rights, and membership in international organizations. A new state desires the diplomatic recognition of other members of the international society. Diplomatic recognition is in international law is a unilateral, declarative, political-based legal act through which the subject of international law, a state or rarely an international organization, states, declares the existence of certain facts and assigns them certain legal effects. Like, for example, the creation of a new state. The object of recognition may be the state, the government, insurgents, the militant party, or the nation. Recognition may be individual or collective by a group of states. Recognition may have a clear character when it is notified to the interested entity in an unambiguous manner that does not raise any doubts. Or it can be implicit when it is not straightforward mentioned, like said out loud, but results from some conclusive facts. We distinguish a recognition de facto, which is limited and incomplete, and therefore conditional, and it may be cancelled, and recognition de jure, which is unconditional and irreversible, and that's the preferable one. As for types of countries, we have uniform unitary states, like Poland. The uniform state appears outside as a single entity, despite having some internal administrative division. The vast majority of the existing entities are uniform states. We have also complex states. The essence of a complex state is the division of sovereignty between the whole and its component parts. In the past, we had real and personal unions of states. Nowadays, complex states exist only as federations, federal states, and confederations, union of states. Though currently we do not have a functioning confederations, they have all changed into federations. A federation has central organs, and therefore it acts outside as a single subject of international law. The federal states give up international relations for the benefit of the federation. Therefore, they have none or a very limited capacity to act in the international relations and are not separate subjects of international law. The most well-known federations are the USA, some Latin American states, and in Europe we have Germany that is divided into lands, and Switzerland that is divided into cantons. Confederation. Confederation is a loose union of states based on international agreement. for the conduct of common foreign and defense policy. As a rule, there is no central executive power. The states within Confederation remain sovereign and independent subject of international law. We have also some specific structures like a Commonwealth, like the Commonwealth of Nations, bound by a person, Queen Elizabeth II. We also have some countries with the limitation of legal capacity in international relations. Those are dependent countries, microstates, and permanently neutral states. First are dependent states. Dependent within the meaning of international law is a country whose ability to maintain international relations and conduct foreign policy is limited to the benefit of another entity. Dependent states are protectorates, international and colonial, and vassal states, though most of them do not exist any longer. Microstates are the second type of internationally limited countries. They may be considered as international protectorates. Microstates have a tiny territory and a small population, which makes it impossible for them to fully manifest themselves in international relations. Therefore, it is in their best interest to transfer representation to another country. There is here in this category we have Liechtenstein, which is bound by economic and political agreements with Switzerland, Monaco, which is the protectorate of France, and San Marino, which is under the protectorate of Italy. All three are United Nations members. Last but not least, we have permanently neutral countries. The most famous one is Switzerland. Recently, because in 1955, Austria joined this category. A state that is permanently neutral in exchange for the guarantee of independence and territorial integrity obtained in an international treaty, so acknowledged by the whole community, or most of the states, undertakes obligations not to use armed force against another state or to enter into ongoing hostiles, except for self-defense. The consequence of this status is exclusion of the possibility of joining military alliances and organizations, participation in the collective security system, and the prohibition of making its territory available for a military base. Other than states, we can discuss the subjectivity of the nation, international organizations, the Holy See, and of natural and legal persons. The subjectivity of a nation was widely discussed in accordance to the colonization process. A nation can exercise the right to self-determination if, in the course of the struggle for national liberation, it would create the foundation of its statehood. That is, develop civil or military bodies capable of representing it at the international level. It can be recognized as subject of international law. Then we have the subjectivity of international organization. International organizations are associations of either countries or other legal or natural persons from different countries established to carry out the tasks specified in the statute. We distinguish GOs and NGOs. GOs are governmental organizations whose members are states. NGOs are non-governmental organizations whose members are legal or natural persons from different countries. Those are associations, parties, and for natural persons, organizations associating scientists, for example. The ones that have international subjectivity are governmental organizations, so GOs. The elements that make up the governmental organization include an association of at least 3 sovereign states. There can be 2 states in organization, but only in case when 3 created an organization and then 1 resigned from being a member. Conclusion of a multilateral international agreement having the nature of a statute. Defining in this statute the goals and methods of functioning of the organization. Appointment of bodies, permanent, not temporary, with designated competences. Sometimes it is difficult to qualify an organization in one of those 2 categories. An example is the International Committee of the Red Cross, which was created as a non-governmental organization, but then was granted by states in international convention, Geneva Convention, some ability to act in the international arena. We can divide organizations in two: universal and regional ones. Universal organizations like UN or WHO, they aim to include all countries in their membership, and their statutes provide that they are available to all countries. Regional one, like European Council or African Union, membership in them is assumed to be limited only to a specific group of countries. We have coordinating and supranational organizations. Coordinating, so they coordinate the actions of the member states, and supranational, where organization bodies are empowered to impose obligations on member states, like in case of the European Union. We have general and special functional organizations divided by the range of competences, and we have open, semi-open, and closed ones, divided according to the possibility of joining a given organization. International organizations are the second most important channel for conducting international policy by states. First one is the diplomatic channel. States are looking for collective legitimacy of their actions through those organizations. Next, we have the Holy See. The Holy See is next entity with the specific international subjectivity. The Holy See, Apostolic See, refers to the head of the Catholic Church, which according to canon law is the Pope, and to his group of choral officers. The Pope's ability to act in international relations was recognized as early as the Middle Ages. In 1929, the Lateran Treaty was signed between the Holy See and Italy, and as a result, the Vatican City State was created therein. The City of Vatican is under the sole sovereignty of the Holy See. The Vatican City is a member of the International Telecommunications Union and the Universal Postal Union, while in international relations, apart from matters of a technical and administrative nature, the Holy See appears more often. And the Holy See is a party, for example, to the 1949 Geneva Conventions for the protection of war victims. Finally, as regards the subjectivity of natural and legal persons. In the case of legal entities, we have multinational corporations here, which, however, are not subject of international law. Multinational corporations carry out activities that go way beyond the borders of one country. They import, they export, have branches in different countries, etc. Their functioning and relations with individual countries are governed by the provisions of internal domestic law. As for natural persons, they are also denied subjectivity, although some norms of international law are addressed them directly, like the prohibition of piracy, prohibition of committing international crimes, which include war crimes, crimes against peace, crimes against humanity, crimes of genocide, etc. In plus, there is right to petition, that is to refer to international bodies connected with human rights. It must be admitted that if an individual has any rights and obligations based on international law, they result from contracts signed by its state. So the individuals do not have rights because they were given to them directly, but in consequence of states being a party of the convention, that assures said rights. Those rights are getting extended over the years. That leads to natural persons gradually obtaining subjectivity on the international level, but not yet. To sum up, we have a high position of states as subjects of international law, and the governmental organizations also have subjectivity in international law. The nation may be recognized as subject. We have specific subjects like Holy See, like the Holy See, and the subjects are non-governmental organizations, legal persons, and natural persons. And that's all from me today. So thank you very much for listening, and I'm saying bye-bye for now. See you soon.